Building on the understanding of the historical background and purpose of the 1967 Arizona Consumer Fraud Protection Act, this section examines the specific elements that make the law effective in protecting consumers, particularly within the real estate industry. Codified under ARS Section 44-1521 through Section 44-1534, the Act serves as Arizona's principal statutory tool for addressing deception, misrepresentation, and concealment in any form of commerce. It is a broad and preventive law that prioritizes honesty and transparency in all transactions, ensuring that both businesses and consumers operate within a fair marketplace. The core elements of the Act can be summarized as prohibition, enforcement, restitution, and prevention. Each of these components plays a unique role in deterring deceptive practices and promoting integrity in commercial dealings. The first and most fundamental element is the prohibition of deceptive acts. Under ARS Section 44-1522A, it is unlawful for any person, in connection with the sale or advertisement of merchandise, including real property, to engage in deception, false promises, misrepresentation, or concealment of material facts with intent that others rely upon such acts. This means that even if no one suffers actual harm, the act of misleading or hiding critical information is itself a violation. The statute was intentionally written this way to emphasize prevention over punishment. Its goal is to stop fraud before it occurs. For example, if a real estate developer advertises a subdivision as fully permitted for construction, when the lots still lack approval for septic systems, that statement constitutes a deceptive act under the statute. The law protects not only those who purchase the lots, but also prospective buyers who might have been influenced by the false claim. Likewise, an agent who knowingly withholds material facts, such as a property's history of flooding, can be held liable for fraud even if the buyer later discovers the truth and cancels the transaction before closing. The omission itself violates the duty of honesty owed under ARS Section 44-1522 and reinforces the disclosure obligations imposed by ARS Section 32-2153 and R4-2 8-1101 for licensees. The second key element of the Act is enforcement authority, which lies with the Arizona Attorney General. The Attorney General is empowered to investigate suspected violations, issue subpoenas, examine witnesses, and compel the production of records. If evidence of deception is found, the Attorney General may seek court injunctions to stop the misconduct and may also file civil or criminal charges. This centralized enforcement mechanism ensures that consumer protection is consistent statewide and that victims do not bear the burden of pursuing costly litigation on their own. In the real estate context, this means that when fraudulent advertising, misrepresentation of investment properties, or concealment of material defects occurs, the state can intervene to protect the public. The third element, restitution, ensures that consumers who have suffered financial losses as a result of fraud can recover their damages. Under ARS Section 44-1528A, courts may order restitution to consumers alongside civil penalties against violators. For instance, if a developer collects deposits for homes that were never built, the Attorney General can obtain court orders requiring full reimbursement to all affected buyers. Restitution serves as both a remedy and a deterrent, reinforcing the message that Arizona will not allow consumers to bear the financial consequences of deceptive business practices. Another vital component is preventive education and compliance oversight, which emphasizes avoiding fraud before it happens. The Arizona Attorney General's Office frequently issues consumer alerts, educational campaigns, and online resources advising the public on how to identify and report scams. This proactive approach aligns with the Act's spirit of prevention and complements the enforcement and restitution measures. In addition, The Attorney General often coordinates with the Arizona Department of Real Estate, ADRE, ensuring that real estate licensees are held accountable under both the Consumer Fraud Protection Act and the state's professional conduct laws. Arizona courts have also helped define these elements through key rulings. In State Ex Relder Babbitt v. Goodyear Tire and Rubber Company, 1974, the court emphasized that the act should be interpreted liberally to protect the public, not narrowly to protect wrongdoers. Similarly, in Dunlap v. Jimmy GMC of Tucson, Inc., 1984, the court ruled that even omissions of material facts can constitute fraud under the act. These cases illustrate how Arizona's judiciary consistently upholds the intent of the legislature to ensure consumers are treated fairly and honestly in all commercial dealings. Together, these elements create a comprehensive framework for consumer protection that applies to all industries, including real estate. They ensure that individuals purchasing homes, land, or investment properties can rely on truthful information and ethical practices. For licensees, adherence to these principles is not optional. It is an expectation codified in law and reinforced by the professional standards established in ARS Section 32-2153 and the Commissioner's Rules under R4-28-1101. Review Summary. The 1967 Arizona Consumer Fraud Protection Act protects consumers by prohibiting deceptive practices, empowering the Attorney General to investigate violations, enabling restitution for victims, and promoting education to prevent fraud. Codified under ARS Section 44-1521 through Section 44-1534, the Act emphasizes prevention and accountability. Real estate professionals are particularly affected because real property is defined as merchandise, making misrepresentation or omission of material facts a direct violation of law. Together, these provisions ensure that honesty and transparency remain the foundation of Arizona commerce and real estate practice. Discussion. What is the primary goal of the Arizona Consumer Fraud Protection Act? Answer. The primary goal is to prevent deceptive business practices and protect the public from being misled in connection with the sale or advertisement of merchandise, including real estate. Who enforces the provisions of the Act? Answer. The Arizona Attorney General, who has the authority under ARS Section 44-1524 to investigate, issue subpoenas, and seek injunctions or restitution. Why is it significant that actual damages do not need to be proven for a violation? Answer. Because the law focuses on prevention, it allows the state to take action before consumers are financially harmed, ensuring greater public protection. How does the Act relate to real estate professionals? Answer. Since real property is defined as merchandise, any misrepresentation, false advertising, or omission of material facts by a licensee can result in a violation under ARS Section 44-1522. Closing remarks. The core elements of the 1967 Arizona Consumer Fraud Protection Act reflect a philosophy of fairness, honesty, and accountability that underpins Arizona's entire real estate system. By establishing strong prohibitions, enforcement mechanisms, restitution opportunities, and preventive education, the Act ensures that consumers can trust the information provided to them in every transaction. For real estate professionals, compliance with the Act is both a legal responsibility and an ethical obligation that enhances public confidence in the profession. Understanding and applying these principles ensures that every licensee upholds the highest standards of conduct in representing buyers, sellers, landlords, and tenants throughout Arizona.